Morning Crossfire on 99.3 Nigeria Info.
All right, welcome. The Morning Crossfire continues. A big thanks to Chef Corey for that interesting, incisive, and analytical Daily Today conclusion right here on the Morning Crossfire. We're still talking about the Supreme Court. We're still talking about the hearing ongoing and, of course, the appeal by three presidential candidates and the political parties. Well, now there are two. And, you know, we have questions on our minds. And some questions are begging for judicial or legal interpretation, legal opinion. And we comfortably have standing by. Our guest this morning is a lawyer who will be doing justice to the questions you have on your mind. And the questions I have on my paper, my script here, regarding the ongoing presidential election petitions appeals at the Supreme Court of the Federal Republic of Nigeria. Dr. C.A.J. Chinwo is a senior lawyer. He is a lawyer who has a bias for the Nigerian Constitution. He's a constitutional law expert. He is a legal educator. He is a lawyer who doesn't want to be a judge. That's why he's still in law. He told me, he's that experience. He could easily be, someone in the bench. I'm sorry, Oga, I exposed you. Good morning to you, sir.
No problem.
All right.
Good morning.
Fantastic. For those listening, if you'd like to be a part of the conversation, please feel free to call us on the numbers. We usually advertise 0700 993 993 993. You can call. We'll take your calls. 0700 993 993 993. For female listeners, if you cannot make it through that line, we have a special alternative line for you, which is 014657190. 014657190. Quick start with you, Dr. Chim. And what's your assessment of the process at a stage that it has gone to, where the parties made their written orders, filed their appeals, and then, of course, written addresses, brief events, and applications to state new evidence, and where we are with the judge or judges reserving, and what's your assessment of the process up to this stage?
Well, I think what is normal is when a matter like this is on time by election matters, whether at the tribunal, the court of appellate court, election bar, everybody, everything has to be done with time. There's no room for extension of time. And the court also is on edge because more than any other time, periods provide the greatest challenges to judges. Have to work almost sleeplessly to attend to everything. Now, in this case, a new direction introduced because of the application to introduce it. It means that court, and because this is that cost the attention of the whole world now. The court has to go there, working, reading, and trying to write the type of judgment they can imagine. So it's quite challenging and quite interesting. And the authority brings the judiciary itself to the desk of trial. Everybody, like with the group, will say all eyes on judiciary, whether good or ill, all eyes on judiciary. But I pray that we Nigerians will be fair in assessing the judiciary. Because I must say, we haven't been very fair in the judiciary. The judiciary has had its own challenges, which are regrettable, but we move on to the judiciary. Those who are, like you mentioned, some of us will ask the judges, and with all of them, thank you, because we know the challenges involved. But those who have studied must ready to meet their responsibilities.
Interesting, Doctor. Please explain to us what exactly happened yesterday. We know that the parties, PM and the PDP and LP and their candidates presented their appeals, and of course the AP and its candidate and lawyers brief of arguments, and then the PD and Atiku presented an appeal, application. Sorry, yes. So for yesterday, let's start with APM. APM withdrew what do you call it? It's an appeal. Because according to what the judge we had, the judge said that the appeal did not have prayers for the tendency. Can you just help us understand what happened there?
Yes, APM appeal. This is what the judiciary will also look around. It came under in the Supreme Court. It is an appeal that shouldn't if the council looked at the property. So the court had a way of making it to follow up meeting court by asking questions. We looked at this. Is it of this or done? Do you think we should do it again? Ultimately, a lawyer looks at this and takes what was taking it. He take the hint of that this is not what stayed there. They won't say they don't want to say withdraw it. They will drive it to a point and withdrawing it. And that's why the application of council will strike it out. What happened with the APM? I think the issue is that the Supreme Court had decided before now, and not long, and it was such that no color should be pushing such issue again. Normally, when an issue has been decided by the court, particularly a court like the Supreme Court or an appellate court, you're expected to abide by it if your court is not higher than that. And the Supreme Court is the ultimate court in the land. So I think that was what happened with APM. the issues they were raising in the appeal are matters that have been handled by the court and determined, even though in another matter, they constitute precedents, and precedents are meant to guide us to say, okay, there's no need, this is what we're asking for, it has been answered before. There's no need flogging that issue again. I think that has what has ended with APM case. Sometimes there's the urge to just try something. But we should remember that the judges are human beings who have to sit down, read and write again, especially the procedure we have. So I think that what happens, so the APM had to go, and the court has to face what they are calling now the main issues, the life cases that are before it, where issues that are raised have not been settled because they are particular to the appeal of PDP and appeal of Labour Party. And that's the way the court works, even in the United States. They will shift the docket and take out the things that shouldn't take their time. Sometimes, the fortunate thing in Nigeria is that it didn't have to come to the open court. In the US, in chambers, such matters, they call your attention and it will run there. It don't come to the open court, it take all the time, the judicial, but that has been done. We must have a holistic review of our procedures and processes and procedures so that it can be easier, and the confidence of Nigeria response to the judicial. So APM is gone. They want for the PDP and Labour Party cases.
All right. Interesting to say that the selection petition court had told APM in its suit challenging the double nomination, alleged double nomination against Kima, the running mate Bola Tinubu in the presidential election. That was what they had gone to court. Like you explained to there was another judgment in this week by the Supreme Court. Is that what you say, sir?
Yeah, that's right.
Okay. So they come back to that same Supreme Court again. I think you guys was after this is God.
Exactly. After the Supreme Court, in the Omeya on Amechi case, Omeya went back to review. Supreme Court said we have a right to be wrong. If you don't like it, that's the way you can do it.
Okay.
You know that
All right. Doc, the Supreme Court in this APM case said only an aspirant who took part in the primary election claimed the outcome of such primary election. We've seen that some cases in this cycle have also gone that way, where they will say it's a party matter, part of the primary. So you can, but there was a case I remember yesterday or this week or late last. I think it's a legislative case where governorship case. I'm trying to remember one of the states. Governor was removed or legislator was removed, senator, and why he was removed was on premise of something that had to do with his primary. I think it did a minority or one of the. I'm trying to remember. And so I asked myself, I'm asking you, if he was removed by the court for something that had to do with his primary by an opposing candidate from another party, and then other tribunals have said only an aspirant on the primary can challenge the outcome of such primary. What's going on, sir?
Well, the problem with it is that just like the big elephant in India, would have made people went to visit blind men, people from different parties. Now, the issue of primaries and pre-matter and qualification, the Supreme Court has pronounced on it. It's that when within the members of the party, it is a primary matter, a pre-election matter. And because the party chooses to bring a goat, to bring a dog, but the party must qualify to contest the election. So if the party you brought not the fight candidate, not our party player, that candidate will say, the man you brought is not under the constitution and under the electoral to contest me. So that is where the supporters have a matter where the court even say, oh, what is party primary? It's a pre-election matter that's not correct to the court. What I cannot do to go and challenge what happens inside your party. But I have to challenge what you produce. Because you produce him to contest the general election. And so that is the life withdrawn. And the Supreme Court has to in many cases. So when it is on court around the look, if you are not by a party primary brought you who is not qualified, then you have no candidate. They are not qualified to go. But if it what happens, Mr. A and Mr. members of the same party, we are fighting or whatever, I don't have right and I have to look into it. That may be the situation where I think the right one is the one that the court will say, if the party is not qualified to contest the election, that qualification issue, and like the Supreme Court said he wants I think around 9 or so, is that one the constitution, not the constitution of the party, which states the qualification. And so when that, the court decides no, you are fine, it doesn't matter if you won the election or you are declared to be winner, you are the right person. That's the matter that we're going to appeal. So that is where it is. Okay. All right, interesting. Doc, let's look at what transpired yesterday again and with co-worker P2B. Well, Atiku's appeal against President Tinubu's election was judgment reserved by the 7-member panel below the Justice Okoro, as well as P2B's appeal. Please explain to us what exactly is going on when we hear that or when they say they reserve judgment. Yeah. I must confess that I didn't watch the entire proceeding. And the reserve judgment, I know that the issue of admission of new evidence is something that they paid attention to. But when the court said we reserve judgment, it's saying that we will give our judgment in a later day. We have heard you. We'll go and look at all your submissions and look at the facts of the case. Then we'll tell you the date where we'll give the judgment. Now, when the court reserves judgment, it means that on that day, the court will read the entire the judgment is given and give all the reasons. But normally, in some cases, the court will just say, today we have had the appeal is dismissed, appeal is allowed, reason to be given later. In which case, the parties may go home from that place, they celebrate, they know the decision of the court, then later the court will come and give its reasons for it, which is not different. So now that the judgment is resolved, it means that on the day that fix, the parties are the whole public to come out their judgment. That's what that judgment means.
All right, but for the Atiku case, what C.A.J did yesterday from reporters were on was he sought to tender the academic records released by CSU, that's civil academic records by and then along the position registrar from CSU. That's what he sought to do. Take his words. This is what he said, quote, praying for of this honorable court seeking leave to fresh evidence on appeal based on the position of from Chicago State University concerning the second respondent to Tinubu, and all that. So that was the argument that the court should admit evidence, pointing out that there were differences in documents. But also the Tinubu came up to ask the court not to do that, as well as INEC. So I think that is what the judge for.
It's not the main appeal.
Yes, that's what I leave it. Okay, so you're saying the next hearing, when communicate to the public, it will be to see whether they want to admit the evidence.
Yes, that's the issue now. They did that appeal. So the appeal is not a preliminary issue of bringing the evidence. That's why I said the judgment, because since the decision will affect the hearing of the it's necessary that we should give a judgment on it before the main appeal is heard.
And there was this controversy. The judge, the lead judge presented to the counsel for Atiku Abubakar, C.A.J, whether he should go with the constitution or the electoral. The controversy was about C.A.J, your colleagues, attempts to introduce fresh evidence after the expiration of the 80 days statutorily provided for filing a trial and termination of election petitions, since this was introduced after the election petitions. So Milord Justice Yokoro asked the C.A.J, how do you bring in this evidence now? Do you want the Supreme Court to brush aside constitutional change and obtain fresh evidence? But what the said was the law only compels the trial not to hear and elect within 180 days. So what do you stand on the issue of constitution versus electoral? Like,
it will not be right for me.
Okay, sorry. Help us understand what is going to help us understand this.
Well, what happens is that on the post of law, when you present your case, you present to the provisions of the law governing the case. If the law says you bring your own evidence as possible to do, and then if there is evidence after that time, and then maybe during the trial, why you bring evidence after the time? In this case now, the office is going to bring evidence at stage of the Supreme Court appeal. The second are very recent, so it is what Judge Left to try to convince the court that they have met the qualifying circumstance in that case. I don't know. So it is judges that will look at the evidence of the facts from both sides and decide whether the circumstances justify it or not.
Okay.
And that's what we are saying. First of all, the social media has already, social media is all. Let us understand that it could be your side. I mean, you can stop a supporter break, and there are something they all have the same passionate commitment.
Doc, permit me to come at this point. We'll go for it. We'll call you back after measures. But I want to take a turn now, because now we're seeing the picture clearly play out. Locality versus merit of justice. Atiku cried mentioned last time.
This is an infomercial.
Boys and girls of Lagos, it has now ended. Yes, the closing date for the objective for the petitions has now been extended. Secondary school students, the age 13 to 16, can still come for the grand prize of 1 million, because the registration will now end on Friday, October the 27th. The process for registration has not changed. Visit our website, nigeriainfo.fm, click the objective banner homepage and complete the registration form. Don't forget to upload 4-minute audio yourself arguing for and arguing a given topic. Successful candidates will still be added via the email, that of yourself, your parents. Again, remember the website nigeriainfo.fm. That is nigeriainfo.fm. Click the objective banner the homepage and begin your journey to registration. Probably
things as well. So that's still money. lead judge, Justice Okoro, stated that he had two letters from the CSU, two conflicting letters. One, which said Tinubu had the correct records from the university, and another letter which is coming from Atiku Abubakar's legal team, stating that whatever it is they're appealing for or appealing with. Of course, we all know that they are claiming that the records are not genuine or were forged. So what happens in this case? Because the judge is asking the Atiku legal team which one he should use. So what do you say to this, sir?
Well, you see, that is actually one of the reasons why the courts are very slow to admit new evidence at the level of appeal, particularly the Supreme Court. Because, you see, when you bring one, the other person brings the other. It means you are reducing the Supreme Court to a court of trial to evaluate evidence. And that is not the work of the appellate court. It is only the trial court to evaluate evidence. So that's why they're giving a hint. The moment you have reduced the Supreme Court to evaluate evidence, you bring a challenge to a source reservation in the whole thing. And that, I think, has given us where the Supreme Court will go. Because it has the power not the law to evaluate evidence. That's why there are two letters that are contradictory. So I just say that I think the Supreme Court will not admit anyone because it is not, doesn't have the evaluate evidence. And the law know that one of us, without taking to what the Supreme decide, I will have been worried that I don't lie or Atiku himself waited until now, bring whatever evidence because if they have advised him, they would have told him that look, that will not be useful for now. He wait for 2027 or another time. Or not, but not a selection the way I understand it.
Okay, interesting. Yeah, wait to see what happens from this. And I wonder how conflicting letters would come from the same university. Another thing the judge told the Atiku worker team led by Chris Uche yesterday was that they need to prove, since it's a criminal issue they're making, they need to prove beyond every reasonable doubt. What mean? What does beyond reasonable doubt, every reasonable doubt in this instance, sir?
Yes, you have to behind the position with all those who reason, who look at things passionately, to be able to say, look, we are convinced. But again, that's what I told you, that is what you do at the level of the Supreme Court. And that's what is giving him. This you are talking about is a matter of proof. If you have letter A from CSU, you have the B from CSU, and you are very different, then you need to convince the court which one is the proper one. You need to bring the CSU to say this one is ours or this is not. All that is not at the level of the Supreme Court. This is the point. So that's why it's to be a forlorn effort to achieve anything. And if the evidence takers are going to say enough for them to build a shiny thing on the otherwise, they should give, because the point is that the time that we have, the content of the law are not such that favor those who are complaining against illegalities in this country. The law is still in favor of a man who has been able to go and ensure the end justifies the means approach. And that is the challenge we have for the election petition. So you hear a case now of somebody say, just get it, let them go to the court. But I believe that Nigeria should get interested in what happens in the law, in the content of the law. When it changes, and I hope that those who have been the law will also change, then maybe things will be different than what they are today. But as it is today, you see that our advantage, anybody want to contest the election, do you have enough talks? Do you have enough money for corruption before you go? Because when you go, that's what will happen. Quite unfortunately, so sorry I have to say that. We have to change holistically this thing, otherwise we're going nowhere in terms of proper democracy.
Because, I mean, for people who are not lawyers like yourself, people like me who are laymen, when we hear proof beyond reasonable doubt, it somehow is almost impossible. But yes, I think we can understand when you lawyers say, and even the judge, Justice Okoro, will say that criminal matters must be proven beyond reasonable doubt, because these are issues that border on criminality, and the consequences are dire. So you must exhaust all doubt. Let's quickly look at the debate between justice, or the debate of justice versus merit, justice or merit versus technicality. In admitting or not admitting the evidence. What do you think about this? Because the Tinubu team is saying that this matter is a pre-election affair, and the court should not look at it. We're not asking you to pass a verdict, but basically, generally speaking, Atiku Abubakar had come out last week to say that he's urging the court, the Supreme Court, to take his appeal on its merit and to look at it from the purview of justice, lessons of justice, not technicality. What do you think about that appeal by Atiku and what's going on?
Well, with all respect, I'm a lawyer and I love justice. But the justice that the court dispenses is justice according to law. The law operates with rules, technical rules. Otherwise, the man in the street will be doing the same thing that I am doing as a lawyer. But the Nigerian nation realized that we must have a group of people who are properly trained to know how to receive evidence according to rules and to administer it according to rules. So while technicalities can be bad when people exalt it beyond the doing of justice, but it cannot be said that to be bad if the law says you should file your case in 2 months and you file it in 2 months and 2 days. You have failed. So we must, even in seeking for justice, you must obey the law. So I know that even those who are arguing that now, we are the people who are also who are champions of technicality. In the other cases, they're arguing. You don't see the way it works. Take, for instance, the lawyers for Atiku, C.A.J, is one of the lawyers we know very well, that as a senior advocate. They will find every hole and every technical thing to fight their cases. Unfortunately, they're on the wrong side now. So that is the thing. But technicalities are important, but it must not be exalted above substance. Now, the justice that is done by the courts is not the justice that is done in the streets. For instance, in the street, if you shout somebody, there's a shout of ole, 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 they'll start beating. It may turn out to be the person is innocent, nobody cares. But the court will say, no, hold it first. Who saw it? What happened? And all that. And I think ultimately everybody would have said that is better than mob justice. So without technicalities, we'll be ending up in mob justice. So I still say that we will not dispose of technicalities. They are very important. That's why it is different between you, a journalist, deciding the case, and me, a lawyer, deciding it. And the moment we ask that, therefore, there's so much justice according to.
Okay, we want to thank you so much for your time, Dr. C.A.J. Chinwo. I have a lot of questions to ask, but only for instance, finally, Shumanovelis, who has a son, who is an APC man, a serving House of Assembly member from the APC, who has a son, an SC, and who on one of the teams at the APC League, she recused herself. I don't have time for that question. Maybe for me after the break, I'll come back to you, and you can give me your answer. Stand by, sir. We're back after this break.
This is an infomercial.
Okay.
Lagos, the biggest educational fair, is here.
Should she recuse herself if this is the case? Yeah, very quickly, please.
Well, I'm saying that there are several reasons why a judge will have to recuse himself or herself from a panel, but it may not necessarily be because my son or my wife belongs to X organization and I don't belong to it. I am a judge. Because the point is not, they cannot scare away people from doing their work simply because of the relationship they have.
Okay.
If there's no evidence that relationship affects the quality of the work they deliver.
Right. Doc, thank you so much. Thank you so much for your time, sir. We appreciate you taking time to explain everything to us. Thank you very much.
Thank you.
All right, that's C.A.J. Chinwo, our guest this morning.
More news and information club will be back in a moment. 19.3 Nigeria Info. More than just radio. Subscribe to our YouTube channel at Nigeria Info FM. Check us out on Facebook at Nigeria Info 99.3. Follow us on Twitter at Nigeria Info and at Nigeria Info FM Lagos for live updates as it happens.